All right, we have a quorum. The meeting is now called to order. Item number 1. Documents issued since the last meeting, none. Information paper issued since last meeting, none. Item 2, items for discussion for the next meeting. Let us invite the government officials into the room. May I welcome the government officials for attending the meeting, and they are Mr. Lau Kong Wan, the Secretary, Ms. Gordon Leung, Deputy Secretary, Mrs. Philomena Leung, Principal Assistant Secretary, Professor Young of the Hong Kong U. Mr. Lau, our date of next meeting is the 20th of January. Would you tell us what are the items that you propose to discuss with us? We propose 2 items, Mr. Chairman. First, the policy address. Sometime next month it will be delivered. And then the second item is in respect of inspecting the voters' registration information on the Internet. In respect of the new election cycle, we would like to discuss the matter with members earlier. Well, you raise your hand. What do you want to discuss? Well, I just want to wait in the queue. I want to discuss anti-stalking. I'm stalking you. No, we are discussing anti-stalking. After the policy address, the officials will come to discuss the policy address with us. That's one of the usual items. The next item is inspection of voters' registration information on the Internet. All right, let's move on to agenda item number 3, and that is overseas experience in implementing anti-stalking legislation. There are 2 documents available. One is CB 2471/1314, the paper provided by the administration, and the other is the one prepared by the Secretariat, which is CB 2471/1314-04. So if I may ask the Undersecretary to take us through the administration's paper, and members may wait for the time to raise questions. Thank you, Chairman. Members may recall that the LLC proposes to introduce legislation on stalking or anti-stalking. 2 years ago, we conducted a public consultation. At the end of last year, we reported to members the outcome of the consultation. Members raised many valuable views, and one among which members want to understand what is being done in overseas jurisdictions in respect of anti-stalking law, taking into account freedom of expression and media freedom. We therefore has commissioned the Hong Kong U to conduct a study, and in fact the study report has been sent to members. Today we are here to listen to members' advice. The director of the Center for Comparative and Public Law has come before members, and the professor is to listen to your questions and your views. And there is comparisons made among 6 jurisdictions, and there are recommendations in respect of the media, and there is a proposal to give exemption to media freedom and also freedom of expression. This is just a recommendation of the consultant. We are to listen to members' views before we move on to further arrangement. Professor Yang, would you like to address the committee?
Thank you for inviting me to today's meeting. Let me try to summarize the results of our finding in a very brief manner, because the summary that is actually prepared in the panel paper is a fairly accurate summary of our findings and our recommendations. We were asked in this study to consider the comparative experience in other jurisdictions in this area of stalking law, and to focus particularly at how these jurisdictions dealt with possible issues involving press freedom and also the interference of freedom of expression and assembly in this area of stalking law. So we looked at the jurisdictions of the United States, Canada, Australia, New Zealand, and of course the United Kingdom. And generally what we found is that most of these jurisdictions in the course of legislating in this area have understood the concerns of media and the possible interferences with media freedom. And many of these jurisdictions have dealt with these issues by providing certain assurances to media that they won't be used in a manner that will interfere with press freedom. And also in some jurisdictions, the assurances are actually given in the legislation themselves in the form of defenses, in the form of exemptions. Let me just say a few words about the difference between an exemption and a defense. There's really no magic to the difference. It's really more a question about the scope of the defense. They're both defenses in nature. But an exemption goes further than a defense that's phrased in vague terms. So an exemption exempts certain categories of conduct or certain individuals. And that we found in a couple of jurisdictions, particularly in Australia and also in the United States. And that was really quite interesting to find such exemptions, because again it showed how the great concern that these jurisdictions had for the possible interference with press freedom. But there are also other issues about how you frame the offense, assuming criminal liability, particularly in how you define the scope of the actus reus, the conduct element that is prohibited, and how you frame the mental element, the mens rea as well. In the 2000 LRC report, the recommendation was to have both an actus reus and a mens rea that was very broad, based primarily on the UK proposals, or the UK law at that time. In our recommendations, we recommend primarily to keep those elements very narrow, particularly because we are recommending a criminal offense and the importance of keeping criminal liability very clear and very strict, tailored to the purpose that you're trying to achieve. And the purpose, of course, is not to impose criminal liability on journalists or anyone who's in the business of expression, but it's to really criminalize behavior where one person persistently harasses another person and causes that person great despair and fear for their safety. And we found that that's a real problem. That's still a real problem in Hong Kong. Nothing's changed since 2000. Perhaps things have gotten worse. But so essentially, the case is that there is a gap in our current law because our criminal law deals with matters that involve violence or threat of violence or intimidation or other illegal acts, but not persistent harassment of one person against another, which in other places, many places in the world, we call stalking. So there's a gap in the law, there's a need for the law, but the response in terms of criminal law should be one that is properly tailored to the purpose and not to overreach and to encroach on fundamental rights and responsibilities. So we essentially, I'll just sort of wrap up here with a reference to the exemptions that we propose. We essentially propose 4 exemptions. One that relates to lawful authority. So if you already have some basis in law for what you're doing, this reform will not change that. Right? So for example, there are provisions in the law that allow for peaceful picketing. So if you're conducting peaceful picketing, you cannot be charged with this offense because you're exempted. It's lawful authority. Right? And then the second category is that relates to media and media organizations. And the conduct that is exempted is the gathering of information for the purpose of communicating to the public. But it has to be pursuant to some contractual arrangement with a media organization. And so once you fall within that criteria, your conduct is completely exempted. So the police would not even think about this charge, we would think, because it's exempted. The third relates to conduct, sort of refresh. Oh, yes, relates to conduct that when people are acting lawfully in their employment. Right? So if you're carrying out lawful employment, and it may well be that you have harassed someone in the course of doing so, that should not come under this criminal law. It's only when you cross the line, when you're engaging in violence or threats of violence or intimidation, then the existing criminal law can come into play. Right? So it's not meant to interfere with conduct pursuant to lawful employment. And lastly, the fourth exemption, which goes together with the second one, is instances where individuals are discussing or communicating matters that concern public affairs. There's one catch to this exemption, which makes it different from the second one, is that you have to be doing this for the sole purpose of discussion or communication solely for public affairs, so for the sole purpose. You cannot use this as a front to harass or stalk someone. Right? And so this would cover individuals such as individual bloggers who don't have a contractual arrangement with a media organization, so they're just blogging on their own, or other individuals who are running a website where they're expressing their views. Because expressive activity on a website is typically not directed at a person. Right? Stalking is a criminal offense for behavior that is directed at a person and causing that person great grief. Right? So internet communication should not be generally criminalized under this offense. So I'll stop here.
Okay, thank you, Professor Sin Yang.
We have some submissions tabled. One is from the Privacy Commission of the LRC, and we also have from the Journalists Association. We have 8 members with questions. Let me read. We have Ms. Claudia Mo, Zhang Laiwan, Li Chao Yan, Yip Kok Him, Xin Zhonggai, Liu Changgang, Sid Ho, Tin Bak San, Wang Bik Wan, Hua Junyan, Xin Zhongkai. Did I miss anyone? No? 5 minutes each. Ms. Claudia Mo. Thank you, Chairman. I apologize. This report has not convinced me because the other jurisdictions you're comparing, first of all, they are democratic societies and they have laws protecting news freedom, including freedom of information and so on. I don't see how you can make a direct comparison. And most importantly, Hong Kong doesn't have real democracy. Hong Kong people have distrust of this government. It's at a precipice. We have a new piece of legislation that is scaring a lot of people. You also see the journalists, Hong Kong Association of Journalists submission. There's no urgency. It just indicates that the government wants to restrict the public's freedoms. So please take note of this. And another issue, the freedom of the press will be affected in Hong Kong. You really need, if you really want to deal with anti-stalking, as you said, Chairman, we can amend the domestic violence ordinance, the landlord-tenant ordinance, we also have cases of couples that can be dealt with by domestic violence ordinance. We have cases and the courts have ruled. If you have people who are in distress, they could call the police. But now we're talking about personal safety. But even staring at a person leading to alarm is cause for calling police. Just now, Professor Young said bloggers are exempted, reporters are exempted. But the question is, your paper refers to exemptions, but then the interpretation amounts to just a defense. So that means they have to go to court, no matter what. Well, the lawyers don't mind that. They say you have a defense. But then how can reporters conduct their work? There'll always be a dark cloud hanging above their heads. They need to appear in courts. And if anybody feels that they're being harassed, they could be a person of interest in the public sphere. So all they need to do is call the police, and this person says that they feel that their personal safety is being compromised. They don't like reporters being here. They don't want to sue the reporters, but reporters have to leave. Well, I'm very happy that the paper says that in the end, the government doesn't have a stance. I was going to ask you a timetable, but since you don't have a direction, we don't need a timetable. So, Basic Law Article 27 says that Hong Kong, we have the right to assembly and so on. But for internet media, if we have a news reporter working for a news station, they are exempted. But what about a person working on the internet? You say bloggers. They are talking about public affairs. Well, I've been to demonstrations. I can say I'm a blogger. I can say that my articles are related to dissemination of public information. So how do you define that? The government needs to consider. We already have copyright laws. If you don't amend that, if you use the existing copyright laws, you can arrest people. So bloggers, they want to have discussions with the government. We are now starting from scratch. We have nothing, and you want to create this piece of law. And since you don't have a timetable, and I would therefore want to ask direction. When will you have a direction? Ms. Mo is correct. In examining other jurisdictions, we ultimately need to consider the local situation. Our direction, our meeting today is very important, so no matter how we legislate, we are here to hear from members to see whether we need further study, or as Ms. Claudimo said, do we need to amend the different pieces of law, or should we have one big piece of legislation? We won't rule anything out at this moment. Next, Ms. Zhang Laiwan. I see in the document this stalking offense. It seems to define a person who conducts a series of activities, and if these activities comprise harassment to another person, so it seems to work from A to B, but I want to know, so A harasses B, B does not make a complaint to the police, but when A harasses B, people around B will be affected, so can they call the police? To use an example, a lot of members of the public have said that they have a domestic helper at home. The domestic helper has borrowed money. The finance company is calling the domestic helper. So these collectors call all times of the day, even during the middle of the night, but the domestic helper doesn't call the police. So ultimately, the employer has to call the police, and after the police have investigated, they might conduct some surveillance and identify who's been calling. The police say there's nothing that can be done. They can only issue a warning. So if stalking can be legislated, so can these types of situations be handled? The employer, will he be protected? Just now, Ms. Zhang referred to certain scenarios. We don't have a legislation in place to regulate what is acceptable or not acceptable, especially regarding threatening or threats. We can't answer you. We are exactly looking at the kinds of scenarios you described to see whether we can regulate that. Ms. Zhang Laiwan. Well, I hope you can dig deeper, because a lot of Hong Kong people are concerned about this. Mr. Lee, I'm concerned whether we are trying to protect those who are being affected by loan sharks, or will we be affecting the press, the freedom of press? Well, if we have a stalking ordinance, so when the chief executive visits when he makes a public appearance, and if people hand him letters, that could be stalking. So you might have a piece of legislation to handle demonstrators. The CE or senior officials might be targets of harassment. So are you trying to legislate for the benefit of for the CE? Second area, freedom of press. Would you have exemptions and defenses, as Professor Young said? So will you create exemptions, or will you allow defenses? But no matter what, it's going to take a long time in the courts. To put it bluntly, lawsuits can drag on and on. A lot of money is involved. So will that affect freedom of the press? This is my concern. I'm also worried that we talked about loan sharking, money lenders just now. So shouldn't we have a money lenders ordinance, just as we dealt with harassment in the domestic violence ordinance? We can narrow the law. We can narrow the money lenders ordinance, make it clear. Well, of course, you shouldn't tamper with the public security ordinance. I think we can handle loan sharks through a separate ordinance, through the money lenders ordinance. When they splash paint or when they make nuisance calls. So could we deal with it piecemeal? Mr. LegCo has expressed his view. We've heard these views in previous occasions. That is, we don't need one big piece of legislation. We can just make ad hoc amendments in current legislation. I had just answered this is one possible route, but the study of stalking had been proposed by the LRC in 2000 because of the public's request. Just now we mentioned the money lenders and other activities.
男女關係等等呢啲嘅情況，又或者一啲咧係可能係即係當時係新聞界嘅一啲嘅即係情況，剛才議員都提咗出嚟，咁所以整幾個嘅情況咧都引起到咧即係法改會咧就希望咧係能夠政府係做呢一個嘅即係定。但係直到今天咧，我哋而家係做緊一個嘅，即係做完一個嘅公眾諮詢，做咗個顧問嘅研究。咁今天咧，大家俾嘅意見，包括李議員嘅所講嘅意見咧，我哋係會翻去咧係會考慮。
唔係，主席，我想去回應下，到底主席係我想去回應下，就到底會唔會係即係亦都可以即係引申，如果係個大法㗎，纏繞大法，即係。哇！好勁啊！個名都真係聽到都驚嚇，會唔會係即係真係引申到係示威嗰度都會受到影響啦嚇？即係變成你哋梁振英又話俾人纏繞啊咁樣嚇。
副局長
，2000年嘅法改會嘅報告咧，基本上咧我就已經講咗，就係針對可能正話上述我所講嘅一啲情況、社會現象，咁就希望咧係訂立一個嘅即係纏繞行為嘅法例嘅，呢個當時嗰個睇法。咁咧就今天我哋去到而家呢個階段咧，究竟係咪做一個嘅豁免？又或者係根據呢個顧問嘅報告做出嘅建議，我哋係去採納咧？我哋未有一個嘅既定嘅一個嘅決定喺度嘅，呢個事實上係咁樣。咁所以咧就剛才李議員所擔心嘅嘢咧，我相信喺未來日子咧。我哋係會即係會聽到嘅嚇，咁究竟係點樣去做咧？我剛才毛議員已經係答咗啦嚇，
即係我擔心係啱嘅嚇，
即係政府而家未有結論嚇。葉國謙議員，
多謝主席。即係規管纏繞行為嘅討論咧，其實歷時都已經係超過10年。咁對呢方面咧，民建聯一路都即係就呢個立法話要制定呢個纏繞呢個法咧，我哋都。即係都覺得係有咁需要，因為事實上喺我哋好多喺地區裏邊或者喺社會上邊咧，其實收到有頗多即係就住呢啲咁樣嘅即係纏繞嚟講，令到好多嘅家庭或者好多嘅人士嚟講咧，喺受到呢部分嘅影響比較。
Many individuals have suffered, and many families have suffered. We have heard the call loud and clear for a piece of legislation. When it comes to actually legislating, then we have to consider many factors, including the issue of press freedom. We have seen this concern. It will become a focus of the proposed bill. Now, there are two approaches. One is to give exemption. The other is to allow a defense. And I have seen the arguments for and against exemption and defense. And there is experience from overseas jurisdictions. When the administration decides to proceed, what factors will you give more weight? Say, there are strong reactions from the media. Well, if the legislation undermines press freedom, that's something people don't want to see. But we also need to consider people's privacy on the other hand. And we don't want, and people don't want their privacy to be eroded. I just want to know what is the inclination of the administration. The Undersecretary. Yes, Mr. Chairman, we know that this is a very controversial and sensitive issue, and therefore we are proceeding very cautiously. We are listening widely to the views of different sectors. We have received a position paper from the Journalists Association, and ex-LLC members also want to give their views. We are listening very carefully. We want to listen widely as well. We want to listen to the views of different stakeholders. I think the most important thing is, where is public interest? Are there victims who are suffering from stalking? And can existing laws prevent such acts? Or should we have amendments to individual legislation, or should we have an omnibus law against that? These are things we are considering. Now, some are concerned about press freedom. The consultant has told us that there is exemption in overseas jurisdictions, and this can address the concern, and also suitable provisions can be enacted to outlaw stalking, and we may be able to find a good balance. We were considering various options, but we have yet to come to any decision yet. Well, I think debt collection is rather common. And if you just deal with debt collection, will that be able to address the issue of stalking or harassment in other categories? Well, we have mentioned various examples, but we are not able to cover all stalking behavior in the community. So even if we amend the law, we may not be able to cover everything. That's the point. Mr. Sin Chung Kai. Mr. Chairman, earlier on, several members raised their concern towards press freedom, and I share the same concern. If I may refer to the paper, paragraph 21, 4 types of acts are included. If you just breach one, that is not adequate to form an offense. It has to be any 2 of the 4, say maybe A plus B or A plus C. If you look at these 4 prohibited acts, do we really need a law to outlaw that? Say B, contacting a person either directly or indirectly, for example, by telephone, mail, fax, so on and so forth. And then I send 2 more letters, then I will be caught by the law. say my colleague, Mr. Charles Mock, has always been stalking his constituents, say by Twitter, by Facebook, by email, by SMS, so on and so forth. So he can be caught very easily. Now if it is caught by B, that is the spam law. The unsolicited electronic messages ordinance that already regulates Act B. Say suppose the person who suffers the stalking, if he refuses or he opts out, then we don't really need B. As the C is by and large also regulated, excluding the letters. If somebody just send letters, then that is caught by C. In terms of stalking or harassment, that is not very serious or strong. Say the celebrities dislike the paparazzi most. Now D is very clear. Following, pursuing, or accosting a person from place to place. That's very clear. That's really harassing or stalking. I follow you all the time, and then I try to talk to you, ask you to say something. Well, in fact, counsellors do come across that very often. And we suffer it. But sometimes we also harass the government officials. A plus D, they are rather physical. They are rather physical, right? As for B and C, that can be done in a virtual manner. It is just in the virtual world. And at the same time, there are other laws regulating such behavior. Maybe the Hong Kong U, the consultant, can enlighten us on that. Are there not relevant regulations or laws dealing with B and C already? Is there any duplication? Now, whether you legislate or not is already an issue. Even if I grant that there is the law, then should it be B and C included? Perhaps Professor Yang can answer the question.
The question highlights only one of the elements of the offense. The question brings attention to what are the external elements of the offense, right? So criminal law has to have external elements. The criminal law can't just be thought crimes. You can't just think it. So you have to manifest this in some way. But there's also the other second element that hasn't been mentioned, and that is it's this conduct that causes a person to fear for their safety, right? And it can't just be an irrational fear, because the proposal is that it has to be reasonable fear, to reasonably fear for their safety. So just sending out 2 emails ordinarily, depending on the contents, but ordinarily wouldn't trigger that other element of causing someone to fear for their safety. And furthermore, again, this is criminal law that we're proposing, right? It's necessary that the mental element is there, the intention, the recklessness to cause someone to fear for their safety.
好，下一位啦，廖長江議員。
Next, Mr. Martin Liao. In the report, comparisons are made between various jurisdictions. They are rather dry, and I'm a bit disappointed. But I have noted that in paragraph 5, there is a marker or reminder. The consultant's proposal differs from the LRC's mainly in that it provides specific exemptions for news and protest activities and activities carried out in normal course of lawful employment, as against the LRC's recommended reasonable pursuit defense and defense for conduct pursued for the purpose of preventing or detecting crime. The LRC has no representative here, but I want to understand the thinking process and the of the consultant and also the grounds for such proposal. With regard to news covering and personal freedom and personal rights, how a balance can be achieved and which parts can be seen in the report. With regard to the proposal of the consultant vis-à-vis the LRC, they are completely different. And which part has been wrong in the thinking of the LRC in respect of providing the defense? With regard to the specific exemptions, will the consultant provide the definition for the media? Does it include the internet stations? Professor Yang, please.
Yes, there's several parts to the question. Your last point first about the definition for media. I think we have to look at the two exemptions that we're proposing, Exemption 2 and Exemption 4. Exemption 2, the thinking is that this would be established media organizations, so that it's a clear exemption to apply. Exemption 4 is meant to be the catch-all, so it can be a one-off, but so long as it's your sole purpose of communicating public affairs. So if you're not protected in 2, you can still get protection in 4, which is a kind of a residual category. Now, in terms of the proper balance to be achieved, I think the proposals that we're recommending build on the LRC's recommendation from 2000. They're not meant to be inconsistent. We now have 13 years of experience to see how the UK provision, because that was what the proposal was from the UK, from the 2000 report, was to adopt the UK position. We now know how that worked, and in many ways we've seen that it has interfered with press freedom, particularly in the civil injunctions and civil remedies. So that's primary motivation to look further beyond the UK. And there are 3 material differences. One, we want to have a clear conduct element. The UK law simply said harassment. It didn't define what harassment was. Here we are defining it in those specific instances that we looked at. Secondly, the mental element has to be subjective, a subjective form of mens rea, rather than objective. The previous 2000 report referred to a ought to have known kind of objective standard, which goes too far. And thirdly, the important exemptions that are specific and not just vague in the form of a reasonable pursuit defense, but clear categories of exemptions that communicate the message that this is not meant to be used against the media.
Well, if Mr. I have a follow-up. I'd like to ask the subjective element. Does that include the mens rea, or is it the mens rea in criminal law? That is the mental element.
Yeah, we're proposing the mens rea of intention, so someone who intends to cause someone to fear for their safety, but also someone who is reckless. Reckless in the sense that you know that there's a risk that the person will fear for their safety, yet you go on and you take that risk. And we also propose a second form of recklessness where you couldn't care. You don't care at all whether that person fears for their safety, and you go ahead.
Mrs. Sid Ho, how do we define media? This is something we're worried about. I will not agree to the stalking, legislating the stalking ordinance. Now, even if you list the details and say that the media, if they are an established media, they have this defense. Well, we're worried that mainstream media now the only written social media will be the ones on the internet. Only those will dare report. And this issue started 10 years ago. And at that time, Mr. Albert Ho said that we should include this in the domestic violence ordinance, the landlord-tenant ordinance, and the moneylenders ordinance. This is where we see the most number of stalking incidences. But the LRC says that there's another area that they can't regulate. Couples. So if somebody is targeted by an unknown stranger, they can still be victims of extreme behavior. So even with legislation, the police don't enforce the law. For example, the domestic violence ordinance, even if we have the law, the police will see couples fighting and they will just say, resolve it in the family court. So you can have one spouse all bloodied and they will only ask, do you want to sue the person who beat you up? Well, our legislation regulates threatening behavior. Well, we have to be very careful. What I want the scholars or academics to understand is that why we have such fear of legislating stalking. Women's groups, our allies, they ambassador us for legislating. But in the last deputation meeting, the majority of women's groups feel that overriding public interest and press freedom should come first. They would rather have stalking be dealt with under the DVO, regardless of whether they are cohabiting or they are in a registered marriage. And Chairman, other jurisdictions, why are they not worried about freedom of press? Because they don't have a CE that issues a lawyer letter to the reporters. They don't have a CE that calls for people to shout at the opposition. Other jurisdictions don't have such practice, so that's why they're not worried. If you talk about the U.S., the First Amendment in the U.S. Constitution says they cannot interfere with press freedom. So I want to tell the administration, if you want to bulldoze through the stalking ordinance, then you should be prepared for a lot of demonstrations. I'd also like to urge the academics, when they examine other jurisdictions and they want to copy it verbatim in Hong Kong, it won't work, because our police and officials are so unique. So very unfortunately, we won't support this legislation. That's an opinion. You heard it? Mr. Michael Tian? I think stalking should be regulated. Like, a lot of celebrities are being stalked, so anti-stalking legislation is needed. But if there's legislation, people are afraid it will affect press freedom. So according to the consultant, there will be some exemptions for press activities and expression of view of public affairs. So, if someone wants to stalk people, they can publish their own papers. They don't need to prove circulation. They don't need people to purchase their publications. So how will you prevent abuse? How will you prevent people from stalking under the guise of reporting? So let's say we have an established media. They are reporting through stalking. But if this news is of no public interest, is that a breach of the law? And if the reporter is a bona fide media worker, he will be exempted forever. So it's two slightly different questions. I'll defer to the professor regarding the abuse issue, but I'd like to respond to Mr. Michael Tian that we don't have a direction to legislate. So if we legislate, we need to clarify the details that you mentioned, especially regarding definition, Mr. Professor Young.
It's useful to make a distinction that you find in other jurisdictions between harassment, which is a very broad category, and stalking. Harassment and stalking. And of course, out there is of course privacy as well, but privacy is way too broad. We're looking at a very narrow category today. Stalking is a subset of harassment, right? And we're using the definition of causing people to fear for their safety. That's when you have stalking, right? And so the question that the honourable member has raised about whether you could have there be a loophole or abuse for stalking by way of reporting, our approach in the report is to say that stalking generally, when you're causing someone, a particular person, to fear for their safety, has to be generally directed to that person, right? So someone who, so if you're reporting and you're writing and you're communicating to people generally, right? I'm not saying it's impossible, but it's very rare that you would be able to cause a particular person to fear for their safety. And so in that sense, that's not the purpose of this law. And so the proposal is really for that the kind of conduct that is directed at a particular person.
My question wasn't answered. How do you prevent abuse? As long as they set up a front as a media organization, they can conduct their stalking activities. I'm assuming, let's say we receive a complaint, I'm concerned for my safety. They might not be convicted, but if I say someone is following me, I'm fearing for my safety. But if they are a news reporter, they have if they have a press ID, then that means they're not. They can't be convicted. And is it the case that reporters can continue their behavior even to the point of causing personal safety? Anything you wish to add? We don't have a definition. The professor could deal with other overseas experience.
Sorry, I now understand your question. The possibility of abuse. The idea is that reporters are doing legitimate activity that is protected by constitutional rights, and so the threshold would have to be higher. They would have to cross the threshold of existing law, which is that you'd have to commit acts of violence, threats of violence, intimidation, or other illegal means, and so the existing law would be used. Otherwise, your conduct is exempted, and that's to provide the assurances for the media.
好，下一位啦，黃碧雲議員。
Ms. Helena Wong. Women's groups, their views were mentioned just now. We would want women to be safe from their spouses stalking or from same-sex stalking, but women's groups don't want to see other public interests being affected, such as freedom of the press or other rights to demonstration be affected by stalking ordinance. We don't see the government respond to the community or women's groups or even the Democratic Party saying that rather than having a large stalking ordinance to regulate all stalking, and the other option would be to break it up, to reduce the impact on the innocent. For example, we can have stalking handled by a domestic violence ordinance. So how does the government assess this concentrated approach versus the piecemeal approach? How would what are your considerations? Why don't you break it up into different ordinances? Mr. Lau Guanghua. Ms. Wong says that women are victims of stalking. Well, in fact, men are victims of stalking as well. So the discussion up till today, we have one point of concern, that is, no matter what route we take, freedom of the press, freedom of expression could be affected. We don't want freedom of press, freedom of expression to be affected. So after this study, we come away with overseas experience. We have some countries with exemptions and some without exemptions. We have the different cases, examples listed by the consultant for your reference. Now, regarding how we won't have freedom of press affected, there are two options. If we have a grand legislation, we can allow for exemptions. Of course, we can still discuss the details, definitions and so on, mainstream media, independent media and so on. The details could be ironed out later. That's one direction. The second direction would be, as you said, not to have grand legislation, but amending existing legislation.
As for amending existing laws, we encounter a rather thorny issue. Say, for example, a certain piece of legislation can be amended to deal with the victims, some of the victims, but we cannot cover all stalking behavior because stalking behavior can be fall under different pieces of legislation. In many countries where there is legislation, they have omnibus piece of omnibus legislation which cover everything. Ms. Wong. Now we are discussing the stalking law. We also have equal opportunity law. Now we have we have law against, say, discrimination on the grounds of family status, disability, gender, so on and so forth. We still yet to have anti-discrimination on sexual inclination. So you can do it bit by bit. It's just like so you can apply the same approach. We are concerned about an omnibus legislation on stalking, which can be a noose around people's neck and tighten people's freedom. Now you say with the anti-stalking law, people don't need to worry about their personal safety, but we are concerned that the anti-stalking law will cause public panic. The administration, yes, I've heard Ms. Wong's view. She prefers a gradual and orderly approach. Mr. Albert Ho. I think the administration understands our position. If a piece of legislation increases the power of the government and law enforcers and limits the freedom of individuals, we are against it. I think that's the spirit of the human rights law. If you want to restrict human freedom, you have to prove that it is necessary and reasonable to do so for a certain reasonable purpose. Now, members have mentioned various kinds of behavior. Say, for example, the community refuses to accept such an act because it harms people. Then we pass laws to deal with that. Say, for example, domestic violence. People have consensus. If we can outlaw stalking within the context of domestic violence. Now, if it is not prohibited by law, then the behavior or the act is lawful. The act is permitted. Now, after legislation, then, if the act is not exempted, then the act is outlawed. Now, at present, the act may be regarded as lawful by people. Now, after the legislation is there, then the act will be outlawed. We have to consider the legal consequences. Say, what acts say in our daily lives, which are very common, have become criminalized. Now, can you give us some, well, let me give you some example. Now, why we need to criminalize such an act. Say, after I've looked at your exemptions, some people may feel that these acts are problematic. They should be prohibited. Say, for example, the CE doesn't like people harassing him. He may be the single person who finds such acts against government officials, following government officials, throwing dolls, or the Lucif. I've forgotten his name. The doll. Okay, don't mention the name, in Cantonese in particular. People don't like that kind of behavior. And there are celebrities who don't want to be followed all the time. Say people use cameras to take photos. They are followed by paparazzi round the clock. Now, it seems that you are proposing to exempt such acts. I find it rather confusing. This is quite a huge project. The professor has to do a very detailed comparison in many countries. I still want to ask this. Now, other countries have their own circumstances, have their own systems, but we don't have such things in place. Well, that's one thing. And we also want to know what are the consequences. What acts do you want to target at? What acts you want to combat? What acts you find it necessary to prohibit? It may be just a single, if it is just a single kind of behavior, you don't need an omnibus bill. So can the Undersecretary, or maybe Professor Young, can tell us what sort of acts do you want to target it? I think Mr. Ho has been following this issue for a long time. Now, since the LRC report in 2000, certain phenomena were mentioned, and certain groups of people had to be protected. And then the report also mentioned the paparazzi, and also the debt collectors, and also harassing between couples and stalking. These are broad categories, but they do not cover everything yet. And today we don't have any statistics because we don't have the law. We don't keep such statistics. But we do need to provide protection to victims against such acts. And that's the purpose. But that is not specific. That is not specific. Can you be more in fact, the examples you've given have already been dealt with by law. Say, for example, the Domestic Violence Ordinance or the Moneylender Ordinance. Either they can be amended or there are already provisions. And some behavior is exempted. Say, for example, for the private detectives or the media, they are exempted. Apart from someone who may be weird. Okay, your time is up. I don't know whether the professor or Mr. Lau can answer this. Now, in fact, the law you mentioned doesn't include stalking. There is no time. You have already overrun. Now, concerning Mr. Ma. Now, concerning my constituents, the entertainment or sector would like to have a piece of legislation to protect them from stalking. As for distinguishing real news coverage and stalking, that's an important issue. Say, for example, if the victim has already told the person who is stalking him or her and tell the one doing the stalking that he doesn't want that, he or she doesn't want that, then will that constitute, will that then subsequent stalking constitute an offense? Can that be done in this way? And secondly, can there be any clear guidelines, say, for example, by the law enforcers or by the court? Say, for example, can there be certain guidelines issued by the court as a reference to distinguish stalking from proper news coverage? I've also experienced this kind of a certain kind of stalking earlier on licensing, on a licensing issue. After I cast my vote, over a long period of time, one or two persons waited for me outside this chamber and followed me. Every time when I walked out, then they called my name. They used some abusive language against me. They followed me for more than 100 meters. And then when I came back, they also followed me. Now, as a public person, is it reasonable to have such kind of treatment? And can this piece of legislation, if enacted, can protect me? I don't think that's related with news coverage. That is to put pressure by harassing or by stalking so as to change a councillor's decision in this council. Is it regarded as stalking or harassing? The Undersecretary. I think Mr. Ma has several points. Concerning the first 2 points, whether there can be certain guidelines, or rather, whether the victim of stalking can remind the one doing the stalking. That's a gentle reminder. But the other is whether there can be some guidelines to define what is proper media coverage and what is stalking. I think the problem is that there is no definition in the law, whether it's a reminder or whether it is a guideline. If one keeps on doing that, you really can't stop that behavior. We've seen that occurring in our community, and therefore the LRC then wanted to have a piece of legislation to regulate such behavior. As for the third point, on Mr. Ma's personal experience, it's not whether it's not only limited to a councillor or a celebrity or so-called public person. One has come across that time and again. He is concerned about his own safety, and that act falls within the definition of stalking. And in fact, you have responded to the question raised by other members. Even if we amend existing laws, we may not be able to cover the categories of people who are suffering from stalking or harassment.
So if these situations arise, how does the victim protect his rights? Any remedial measure? Well, then we might need to legislate. So, you can't rely on the existing legislation. Mr. Allen Lau? I'd like to look at paragraph 24. The consultant sees the need to exempt news gathering and expressive activities related to public affairs. The consultant also agrees the anti-stalking legislation of the UK the case law shows that the anti-stalking legislation of the UK has been used against the media and demonstration, and that the vague reasonableness defense has arguably not proved sufficient protection to the media or peaceful demonstrators. Well, I think this is of public concern. In their footnote 16, the consultant considered that legal interpretation of exemption is the same as defense in criminal law. The word exemption instead of defense is used in the report to signify that the activities are being excluded from the ambit of the criminal offense. I joined this meeting late, so this question might have been asked. According to my understanding, a defense, such as a reporter or a person who is expressing his views, has to be engaged in a court case. He needs to provide proof. He has to prove that the defense element is valid to escape conviction, but exemption, well, then he shouldn't be in a court case in the first place. The law enforcement agency should not have sent him to the courts to prosecute him. So why are the two the same? Is my understanding incorrect? Is my understanding of footnote 16? I'd just like to a clarification. Professor Young, could you respond?
There's no magic to the distinction between defense and exemption. We use the term exemption because it is broader and it is clearer. And what I think what is important to note is that we also recommend that this should be a defense in the nature of an evidential burden only, not a legal burden of proof on the defendant. But to the question about police charging, This goes back to the test of reasonable grounds to suspect. And you remember from the Falun Gong case, Yang Mei Wan, the Court of Final Appeal says that reasonable grounds to suspect must relate to every element of the offense. And so therefore, if it's very clear that the defense or exemption, whatever it is, applies, then you don't have reasonable grounds to suspect. You cannot arrest the person, right? But we call it an exemption because we want a very clear defense and very broad, so that the police, any law enforcement will see, this exemption is going to apply. We're not going to take it any further. So that's really the only difference.
主席，我多謝啊。
I have to thank the professor for the explanation, but if the reporter or the person applying his right to express opinion, it is important in the actual application. If you just say it's a defense, they might need to set aside money for lawyer fees. But if it's an exemption, and as the professor said, he doesn't need to worry because the law enforcement agency should not have prosecuted him in the first place. So in actual real life situation, we're not doing an academic discussion. What would your legislative suggestion be?
I think the more important distinction is the quality of that defense. Is it phrased in terms of reasonableness, which is vague, and therefore, yes, you would need to go to court. The charge would probably be laid because people can disagree on what is reasonable or not. And that's what we're suggesting not to adopt. Instead, we're suggesting a very clear exemption or defense that's based on visible or external conduct and elements that you can ascertain in advance very clearly.
好，因為時間關係呢，我哋而家仲有3位議員呢，佢。
We still have 3 members with questions. We won't have the second round because we should have started the second item at 20 after 3. We're late by some 30 minutes. We also have some deputations waiting. So let's conclude the 3 questions. We have Paul Tse, Chen Ginbo, and Lei Wai-Keng. And we'll end this session. Looking at recommendations in paragraph 52, they call for more studies of stalking in Hong Kong. There should be evidential-based policy. And so does the consultant feel that Hong Kong is unique? We don't have sufficient evidence to move forward towards legislation. We had the LRC report in 2000. Some people say it doesn't matter if we wait a bit more. Some people say we should move forward immediately. So what is the government's stance? So even though some people say Hong Kong doesn't have real democracy, Hong Kong is unique, but we have Article 27 of the Basic Law. So even the UK, Australia, Canada are not as clear as Hong Kong. So regarding to Article 27, how do you balance the different views? And third, it seems the report leans on certain areas. We just look at California and Nevada in the US. Australia, they only look at Victoria and Queensland legislation. So these states or provinces have their reference value, but if you look at more liberal areas in the States, or New South Wales in Australia, is it because they don't have similar legislation, or they don't have stalking as part of the criminal code? So have you therefore limited your area of study? We also had members calling for a grand piece of legislation. So what do you mean? So is it because of these reasons you limited your study to 4 jurisdictions. Third, I'd like to ask the question about exemption and defense, the difference between the two. So, I think criminal lawyers will be familiar with that. So, could you take one step further and could you clarify it, which parts can be exempted, so we don't need to have, even though the professor quoted the Falun Gong case, could we clarify it earlier to make it more feasible?
Okay, thank you. Right, I think there were 3 questions that were asked. The first question is about the sufficiency of the evidence to move the reform forwards. I have to say that our study wasn't, we weren't instructed to actually do an empirical study of the need for reform, but we were asked to make recommendations for the way forward, and as part of that we had to do the best that we could. But what we found is that many other countries, they will systematically do surveys, usually in the form of victim surveys. So they survey the public and say, have you ever been the victim of stalking? And what we noticed that there hasn't been a systematic survey done of that kind. So what we did is we did the best that we can to come up with anecdotal evidence. And if you look at the full report, there are several pages on the collection of anecdotal evidence, both in the 2000 Law Reform Commission report and then since that time as well. And there's probably a lot more that we didn't capture. So we think that based on the anecdotal evidence that there's evidence of need. Secondly, on the question of choice of jurisdictions, we did look at the other states. Of course, there's a question of practicality. We can't cover all 50 states in any great depth. But why we chose these particular states, not because of whether they're liberal or conservative, is because we thought that their exemptions were very interesting. In that how they use very specific exemptions or defenses that related specifically to media conduct and activities. And so we wanted to investigate those further, and that's why we looked at those. And just very quickly, lastly, defense and exemption. I just ask that you maybe read the parts of the report, maybe you have already, but in the parts of the report, the full report, we do explain the meaning as we contemplate for each of the exemptions, and maybe that provides some more guidance as to their meaning.
Mr.
Chen Ginpo, I just want to express some views. The LRC called for independent stalking ordinance legislation. The report has also called for clarification and exemptions for the media. So I think normal media reporting should not be affected. So the government should promote legislation as soon as possible. Ms. Starry Lee, I have some questions. I'd like to ask, first of all, the exemption. So, expression of public views on public affairs and news reporting, do these have full exemption? We understand that normal news reporting should be protected. But in fact, we might have different forms of reporting, and I'm concerned some people will conduct stalking under the guise of reporting. So what views does the consultant have on this? Second, regarding the offense. So in paragraph 21, ABCD, two out of 4 have to be breached. So where did you get this idea from? Which jurisdiction? You also, it's not clear, because if you say watching or loitering outside of or near the building or place where a person resides, works, carries on business, studies, or happens to be, Well, if they conduct a news report and they leave, but how long does it take? A week, 2 weeks? What's your consideration?
First question about the exemptions. And I think this was asked earlier about stalking in the guise of reporting. I think that the answer to that is that you'll have to look at exemption B and D. And under D, right, it has to be the sole purpose of discussing or communicating matters that concern public affairs. So if it's not for the sole purpose, if you have an ulterior motive to stalk someone, you're not going to be able to use this exemption. But B, as I said earlier, it's meant for more established news organizations. So the presumption is that these news organizations, generally speaking, and people who are contracted to work for them, will act for the legitimate purpose of gathering news. So that's the presumption. That's why they don't need to prove sole purpose, right? And so you may say, okay, there may be a loophole here, but we would simply say, let's not mess around here with bringing litigation. Give them the blanket exemption. If they go beyond the line of violence, threat of violence, intimidation, or other lawful means, then use the existing criminal law to deal with that. Don't use this new law. The second question relates to the Actus Reus Recommendation 5. And the question is about where did this come from? Well, this came from the other jurisdiction. This is not new. In fact, this is very traditional ways of defining stalking in the other common law jurisdictions. And so it's very well established. The idea of why 2 acts? Well, it goes back to the idea that it should be a course of conduct, that a single one-off incident should not be enough. Because people get very hot-headed, and maybe you can cool off. But it's a course of conduct that we're criminalizing, so at least 2 acts. And of course, it could be the same act. As to the time difference, why draw lines? Why should it be 1 week? Why should it be 24 hours? Drawing lines always gets you into problems. And so it comes back to the causal element of causing someone to fear for their safety, reasonably fear for their safety. And those will depend on the particular victim you're dealing with and the circumstances in the case.
我有跟進嘅，第一就係關於嗰個最少2項個建議咧，根據我嘅。
At least 2 acts, according to my understanding, other jurisdictions don't require the 2 acts instead of 1. If in other jurisdictions they only outlaw that if there are 2 categories of acts instead of 4, then give me the example. Now we understand normal media coverage, but it's very easy to be a journalist, and people may claim that they are doing it for public affairs. How can you strike a balance?
There is a passage in the paper where we do talk about the jurisdiction, the approaches of the different jurisdictions. I don't have the precise paragraph at hand, but my recollection is that most of the jurisdictions that we studied talk about a course of conduct which involves 2 or more acts. Although, yes, there are some jurisdictions that may say that 1 act is enough.
可唔可以舉？
Can you tell me the name of that jurisdiction, please, Professor Yang?
I believe Canada says that 1 act is enough. So.
咁2個咧？
What about 2 acts? Which jurisdiction? Or at least 2 acts in what jurisdictions, please?
Okay. Actually, let me just correct myself. In paragraph 1179, we say that this approach, to constitute a course of conduct, there must be at least 2 occasions of prohibited conduct. This approach is adopted in Canada, New Zealand, and California, and also follows the LRC position.
I think 2 occasions is a bit different.
副局長，
翻譯上高。
I think there is a difference. I think 2 acts doesn't mean A, B, and AC. If, say, A 2 times under A is still 2 acts. Okay. we conclude our discussion on this item. I thank Professor Yang for coming to explain the matters to us. Let us move on to item 4, and that is the second study by the working group on URS of the UNHCR. 2 papers have been issued to members. One is CB 2471-1314-05, and then the other is bracket 06 provided by the LegCo Secretariat.
各位團體代表就
we are the representatives of we have overrun with regard to the previous item, and therefore there's a bit of delay. May I welcome the deputations for coming. You'll be given a chance to give your views. Each of you will be given no more than 3 minutes, and I'd like to remind you that your views are not protected by the Legislative Council Powers and Privileges Ordinance. I will invite you to give your views later. We have a timer, and when the buzzer is sounded, please stop speaking. Concerning the government officials attending the meeting, they are Mr. Lau Kong-Wah, the Under Secretary, Mr. Zhang Toi-Ching, Principal Assistant Secretary, Ms. Millie Ng, Principal Assistant Secretary for Security, Mr. Stephen Seal, Commissioner for Rehabilitation, Mr. Godfrey Khan, Senior Assistant Solicitor General, and Mr. Michael Yao, Assistant Secretary for Constitution and Mainland Affairs. If I may ask Mr. Oh to give his views first. Thank you, Chairman. The SARG government submitted the second review report to the working group on UPR of the UNHCR. The report is far from perfect. It has covered various areas such as press freedom, poverty, extensive police power, undermining human rights, women's rights, and ethnic minorities, so on and so forth. I will speak on constitutional development. We have a detailed paper submitted to the Secretariat. Mr. Li Fei, Director of Basic Law, before the start of the consultation on constitutional on political reform, said visited Hong Kong, and he gave his view. He set the tone. He said that, and also the CSOA later then announced the consultation paper on Election C 2017 and also Election LegCo 2016. They said that any proposal that gets around the decisions of the standing committee, MPC standing committee, is against will not be acceptable. But this is just their own interpretation. The so-called nomination, anything that gets around the nomination committee is not against the basic law. In fact, there were discussions. For example, there are the discussions by the True Universal Suffrage Alliance. You may have seen this before. The academics have already given 3 options which will not have any screening for public discussion. Different political parties and groups and academics have been drafting or have drafted certain options so that members of the public can discuss them. Carrie Lam in the recent API said that there should be discussions. Why can't they be more open to listen to various options before deciding what option is more suitable for Hong Kong? I think that's more important. Now we want to have a true discussion instead of you set the tone, you set all the preconditions, and we can only have the freedom of living in a birdcage. As for the district councils, the administration introduced reform of district administration. The administration wants to devolve power, but that is not effective. Say, for example, in terms of appointment, financial resources, and drawing up of constituency boundaries. Should there be better arrangement? The individual district councillors has overlooked the overall interest. Your written submission has been tabled. Next is Mr. Alvin Young. Chairman, we are on the issue reviewed by the Working Group on Universal Periodic Review. Now, we want to speak on human rights. We are a signatory. Therefore, Article 39 of the Basic Law provides that the relevant conventions continue to apply to Hong Kong. And because of this, we have the BORO. The BORO is based on the ICCPR. Now, let us look at Article 25 of the Basic Law. Or rather, Article 25 of the ICCPR. You're very familiar with that. Even the Undersecretary is very familiar with that. All citizens, disregarding their background or ethnic background or gender, they have equal rights to vote and to be elected, and it has to be the right to vote has to be universal and equal. Now, Article 25 of the ICCPR, put it in a context. We have no religious or racial discrimination, but in terms of political preference, are we free from unreasonable constraint? Do we have equal right to be elected and stand for election? Let us put it to the C election last year and also the previous C elections. We know that not everybody is equal in respect of standing for election. 2012 election, only 1,200 people can nominate and can vote. Only the 1,200 people could nominate. Last year, LegCo election in functional constituencies. In the traditional functional constituencies, only 200,000 odd people could vote. Is it universal and equal suffrage? The answer is obvious. And because of this, in the 2017 and 2016 elections, we are most concerned about this. The CE election in 2017, there will be screening basing on one's political preference. It's not in the consultation in the consultation paper. The requirement is that you have to love China, love Hong Kong. In the future, because of this yardstick, people with different political inclinations have been screened out. The Civic Party is of the view that this is in breach of the ICCPR. I hope that the consultation should clearly define that. Next. Mr. Chung Chi-ho, the UNHCR in 2012 passed a declaration to support LGBT groups and condemn violence, harassment, discrimination, exclusion, and smearing because of sexual inclination. Since 1999, the UN has time and again criticized the Hong Kong government for not providing legal protection to the human rights of the sexual minority. The administration just responded, responses by education. In the latest review report, the UN asked Hong Kong government to legislate against discrimination against sexual minority. In October this year, the Hong Kong U conducted a survey on the rights of different sexual inclination. 65.8% of respondents of the view that Hong Kong should have legislation to protect people of different sexual inclination from discrimination. 22.1% is the view that there should be a law to protect homosexuals. Although human rights should not be decided by the majority view, according to surveys by EOC, academic institutions, and other groups, opinion has swayed. More than half of the respondents are in favor of legislating to protect the sexual minority. The administration should not dodge the issue. Anti-discrimination is to provide equal opportunity to everybody. That covers employment, club membership, renting a home, and things and similar matters. These shouldn't be based on sexual inclination, but on the work performance and other matters and ability. In fact, we have been fighting for the legislation for more than 20 years. Homosexuals who suffer from discrimination have not been given a fair deal. They have lost opportunities in education, employment, provision of service, renting a home, so on and so forth. The legislation against discrimination is not to give special privilege, and it will not break up heterosexual home as alleged by the Society for Truth and Light. We just want people not to live in a world of discrimination.
Nation cannot be changed. We have people coming out of the closet, but there are also people who don't have the courage. They can only choose between coming out of the closet and making a living. So we should have sexual inclination discriminatory laws so that everybody can compete equally at the start line. So the three deputations have spoken. We now move on to legislators, LegCo, Secretariat, and Sid Ho. 5 minutes. LegCo. I understand Article 39. The British colonial government, they had scrapped the election portion. They said, wait, we have something to say. This is an old story. So it's not taken. So universal suffrage is not taken seriously. Carrie Lam's report can be summarized in 20 words. Anybody can be nominated and can run and could be voted for or elected in an election. It's less than 20 words, but she spent 3,000 words to describe it. So nominating committee, this is a fake question. The central Chinese government, if they give Hong Kong people universal suffrage, so do these three principles have to be implemented? Then the nominating committee should just be a tool. The nominating committee should not be the ends, and you need to clarify that. Why should the house be more important than the owner? You can so when we're supposed to comply with the basic law, the framework of the basic law, they say that Li Fei says the person has to be patriotic, has to love Hong Kong, love China. So it's not a tool. So people will have to select who is eligible for an election. Well, are you going to give me universal suffrage? If not, it's a waste of time. The Communist Party can't answer us this question. Why do Hong Kong people's rights to universal suffrage are affected? They can't answer that. Mr. Wong Yuk Man is not here. I'd like to speak on his behalf. When Mrs. Carrie Lam and Chairman, you remonstrated him. But if you're serious, if officials are serious, if you remember the Johannesburg principle, so even if Wong Yuk Man says he wants to throw a petrol bomb, you can't arrest him. Because when we had the argument over Article 23, we had the pro-government camp, the chairman, Mr. Lau Guanghua. The Johannesburg principle was in place. It's only when the actions occur that you can arrest him. So what's all the fuss about? So 10 years ago there was a Johannesburg principle, but 10 years later there's no Johannesburg principle. I'd like the Pan-Democrats to discuss this, give us universal suffrage. So nominating a person to run for CE, that's about 20 words. What is the Communist Party afraid of? They're afraid of these 20 words. So give me universal suffrage. So so I think discussions with the Communist Party is very simple. Just reverse your requests. So let's stop this discussion. Time's up anyway. Mr. LegCo. First of all, you should not take credit for minimum wage. We call for annual reviews, but I'm giving you another opportunity to take credit. If you review it annually, then you need to respond to the ICCPR. We wanted you now say we have annual review now. So if you can't achieve an annual review, you should not take credit for that. Second, you are reporting to the UN. I was watching the live broadcast. All the focus was on China. We all know how human rights is in China. So there wasn't a lot of attention in the Hong Kong report. So political reform, we would have to progress along with the basic law, but this was avoided. the Convention of Civil and Political Rights, Article 25, was avoided. So if this is an international responsibility, if it's in conflict with the People's Congress, we cannot have unreasonable limitations on the nominating committee, but there is a screening process. That is an unreasonable limitation. And when you add further restrictions, then you are in conflict with the international responsibility. No, you weren't asked this question. We are aware that the whole report, you have not explained the conflicting areas with the ICCPR. Regarding this issue, if you look at the convention contents, each jurisdiction, they need to draft their own election framework. It has to be in line with local economic history conditions. So Hong Kong has the basic law. We also have the central government decision. So we will implement our work along these two guiding principles. We have just conducted consultation, and you can see there are different views and options being mentioned. So in the coming few months, we need to listen seriously and attentively excuse me, you're just repeating your pre-programmed stance. I'm asking, how do you deal with the International Convention on Civil and Private Rights? We have Article 25, the nominating rights should not have unreasonable restrictions. What is your response? I had already answered. Under the convention, there is a guideline that is local conditions have to be adhered to. There is a crucial issue that there cannot be unreasonable restrictions. It's because of this spirit we have to implement the spirit in the universal suffrage exercise. Smith Sidho, in the annex, the methodology and consultation is described, but you weren't asked any questions. But in the annex, it mentions sexual inclination. In paragraph 19, you just say that there has been with education, and there has been publicity and promotion. In 2012 June report, there was no response. In our public consultation, it's like waking up from a dream that 2/3 of people want to legislate against discrimination. So on the basis of paragraph 19, that is undertaking extensive publicity and promotion with a view to fostering in the community a culture of mutual understanding, will you take a step forward? Last year, we asked for legislative consultation. Now there has been no consultation, and we're all upset about this. But now the Equal Opportunity Commission says they will do consultation. You have pledged to convene a committee Ms. Priscilla Leung wants to withdraw from that because they cannot come to consensus. But I could have predicted that long ago. We've had no consensus over the last decade. So everybody just boycotted the government and withdrew from discussion. So aside from waiting for EOC consultation, so this committee might be on its last legs before they draft their final report. What concrete steps do you have to prevent discrimination against the different sexual orientations? Mr. Lau Gongwa. Thank you, Ms. Sid Ho, for your concern about one of our working groups. This working group is convening people of different views, and we'd like to see some progress, and in the discussions we'd like to seek further development. As a matter of fact, the group has convened twice. There has been some consensus. For example, we will have a study, in-depth study, to investigate the sexual minorities. How severe is their discrimination? What problems they run into? So that has been a request. So in the coming 6 months, we will come to a view. And this month, we have an API describing the message of non-discrimination against the different sexual orientations. So even though we've convened 2 meetings, we do have some progress. We fully understand this is a controversial issue, a sensitive issue, so we're handling it step by step. And even though we cannot have full consensus, but if we can have some consensus to do some promotion and education, we will do so. Our working group has 2 years to complete its assignment.
Yes, Mr. Ho. Is there any duplication between the study of the working group and that of the EOC? We've already got an institution to start the work, but the EOC has yet to start its work. So I cannot give you a reply on that. We should have ended our meeting at 4:30. 2 more members are in the line, and they are Mr. Chen Chi-chin and Mr. Albert Ho. And then after they've asked their questions, I'll ask the Undersecretary to reply, and then we'll end our meeting. Thank you, Chairman. Before I give my view, Mr. Leung Kwok-hong said that he was speaking too fast and asked me to add 2 more sentences. Mr. Leung Kwok-hong said that if there is universal suffrage, then he's willing to be a homosexual, and if but in fact the Communist Party, which doesn't give universal suffrage to Hong Kong, is some sort of a homosexual. Now, with regard to the controversial issues in terms of constitutional development and protecting the rights of sexual minorities, there is not much progress. Now it's said that the SARG will work with the community to promote a culture of mutual understanding, tolerance, and respect. With regard to legislation to protect discrimination on the grounds of sexual orientation, is there any progress? Last year's policy address, there was an intention to conduct a consultation. Last week, I confirmed it from from an undersecretary. I just want to know what is the government's policy intent in the legislation in this regard. In terms of protecting the sexual minority, it comes under the CMAB, but that portfolio should cut across different bureaus. There are other aspects which cannot be covered by the CMAB. Say, for example, W's case is under the Security Bureau. The AJLS panel finally, or rather the administration finally wants to amend the law in terms of same-sex sexual act. And also the CNS department has to conduct statistical studies on sexual minorities. They all fall outside the CMAB's portfolio. I'm a member of the working group on sexual minority. We had 3 meetings. Outsiders are afraid that this is a kind of the administration dragging its feet. But in fact, those who are inside, who are in the group, are also concerned whether the administration is dragging its feet. I've considered withdrawing from that if there is no progress. Now, in Para 19, it said that more resources will be put in this area. You mentioned this working group. You conduct an in-depth study and you have an API. Can you show us any results? Is there any measurement of success? Can there be more concrete action? The Under Secretary, concerning the inter-bureau efforts, I agree with Mr. Chan. If you look at W's case, it has there will be interdepartmental discussion, inter-bureau discussions. Although in the future the Security Bureau will take the lead in amending the law, the study, the discussion is between within is among different bureaus. As for the sexual minority, we are working on that. The in-depth study I mentioned is a very important basis. We've invited people with different views to sit together because we want to form a common ground on discussing certain issues. The in-depth study will enable members of the working group and also members of the public to understand the situation of discrimination, the width and depth of discrimination, so that we can have the common ground to move forward. Whether it is to legislation and how to legislate, there are different proposals. But if we are to move forward, we need to do consultation. But we have yet to come to this stage. I think we need to first establish common ground. Ms. Albert Ho. Now concerning the UPR, the administration didn't answer much question because most of the questions are related to the CPG. Now, in answering a question asked by the Myanmar Republic, they asked us about political participation. That made us a laughing stock. They laughed at Hong Kong. They may even overtake Hong Kong in terms of political, in terms of democracy. Now, Myanmar is opening up and they will soon have universal suffrage. By 2015, when they have universal suffrage, and if Aung San Suu Kyi is not allowed to participate in the election because she can not get enough nomination because of restrictions on nomination, will we criticize Myanmar for having such a faked election? Well, it's not appropriate for me to comment on that. The Myanmar government raised a written question in respect of the political rights of the disabled and also the employment situation. And we gave a comprehensive report on that. They ask about political participation in your paper, right? They also ask about the disabled, but you just answer the question on the disabled, but you don't address the question on political participation. Maybe you are afraid of the rapid progress. By 2015, if Aung San Suu Kyi can participate in the elections, but many people in Hong Kong cannot, then Myanmar will overtake Hong Kong and Hong Kong will become a laughing stock. Will you have this impression? Concerning the question raised by Mr. Ho, his emphasis is on political participation and political system. But in fact, the main issue is about the people with disabilities, the political participation of people with disabilities, and also their employment. The subject is PWD. But they say political participation. The interest is not about political participation of people with disabilities. They're concerned about the employment of PWDs. Now, I think you interpret the report like to interpret the basic law. Now, you say we are moving gradually and orderly towards the final goal of universal suffrage. And then you mentioned the decision in 2007, you mentioned 2017, there will be election by universal suffrage. Then people will say that 2017 is the final target. You are moving towards this target. Now you give people the impression that by 2017 it is the ultimate target, instead of saying that 2017 is a new start and there will be further gradual and orderly progress. And I really don't know what further progress will there be and how long will we have to wait. Now, gradual and orderly progress refers to the evolvement or evolution in our political system. In 2017, we have a target of electing the CE by universal suffrage. By 2017, will be universal suffrage is the target rather than something like universal suffrage, but not the final target of universal suffrage. So according to you, is it that 2017 universal suffrage is the target rather than a gradual and orderly progress towards universal suffrage? Chairman, I've already answered the question. Okay, if there are no further questions, we conclude our discussion on this item, AOB. If there is none, date of next meeting, 20th of January, 2:30 p.m. Thank you very much.